like to welcome you all to Safeguarding Data, Unraveling the Digital Personal Data Protection Bill 2023. I am thrilled to be with you all today as we delve into one of the most critical topics in today's age, data protection. But before we dive into the discussions, let me introduce our distinguished panel of experts who will guide us through this journey. First, we have our Chief Information Security Officer for Pinnacle AI, Kaushik Hatti. And joining us next will be our co-CEO, Ranjini Venkatraman. Last but certainly not least is our CEO, Rangan Venkatraman. Our agenda today for this webinar includes an in-depth exploration of the key provisions of the Digital Personal Data Protection Bill, its potential impact on businesses and individuals, and its broader implications for society as a whole. We will also have a Q&A session towards the end, but please make sure to jot down questions as they come up. Without further ado, welcome all, and let's begin our journey.
Yes, so let me start with asking the very basic question. So what do you mean by personal data?
Personal data refers to information that can identify or be related to a specific individual. The definition of the personal data is basically when processing refers to wholly or partially automated operations where digital data is stored, the collection, the storage, the usage, as well as the sharing of that information.
Right, so going on to the next question, which talks about consent and its implications. So what should a notice contain before seeking an individual's consent?
So let me start by saying that the bill covers the processing of digital personal data in India, whether we are talking about data that's collected online or offline, as well as any data processing that happens outside of India when targeting goods or services within our country. For lawful data processing, an individual's consent is essential. A detailed notice about the data collection and processing purposes must be provided before seeking consent. Consent can be withdrawn at any time. Data principals are those individuals, like all of us, who have and need to have access to our details. We are allowed to seek corrections, nominate representatives, address grievances, as the case may be. We also have the right to lodge complaints, impersonations. However, doing it falsely would create a situation where we could be penalized. So I'll define what a data principal is. A data principal is individuals like each of us, the 7 or 8 billion people in India are all data principals. Data fiduciaries are those which are enterprises, and enterprises like Pinnacle, as well as other enterprises whose representatives are part of this webinar. So we have specific obligations. As principals, we have certain obligations. As fiduciaries, we have certain obligations. As a fiduciary, we're supposed to ensure that there is data accuracy. We are supposed to prevent a breach and notify anytime there is a breach and an accidental deletion of data. That is at the center of this discussion. So in this process, we can be even asked for consent, and those can happen at the time we voluntarily provided. Exceptions to those rules exist when there are medical emergencies, employment-related purposes, and or other government-related requests.
Okay, let's talk about exemptions now. So can the central government exempt certain activities from the bill?
Yes, certain fiduciaries, termed as significant data fiduciaries, for example, can be exempt. Case in point, the government. So you can have the central government be exempt. However, as enterprises, which I'm assuming most people in this call are, we as data fiduciaries, especially those that deal with large volume and sensitized data processed information, should make sure that they're compliant. And that compliance is essentially at the heart of this. And certain companies may even need a data protection officer or should hire a virtual data protection officer or a firm that understands data fiduciary needs and ensure that they're following the compliance.
So I wanted to ask you, so how long is the tenure of board members of the Data Protection Board of India?
The Data Protection Board typically lasts for 2 years. and they are subject to changes every 2 years.
And how does the bill treat data processing in the interest of national security?
In the interest of national security, the government can essentially, order and use it for research, for archiving, for statistical purposes, for any of those things. The government can essentially take over that. And since data is collected for various purposes, it can be combined. It can be used for profiling citizens. Requiring consent would give individuals more control, of course. However, the government actually, has the obligation to both protect as well as for the greater good, use it for purposes beyond the individual's authority.
So that leads me to the next question is, what does the bill say about overriding an individual's consent?
Overriding an individual's consent happens when the data is essentially collected for public reasons. An example of that could be in the event of a crime, in the event of certain situations, the government can essentially apply and take over. So requiring consent in those cases are not required.
Tell me one thing, Rangan. How could this bill provision impact our citizens?
So number one, the whole purpose of this bill is to make sure that individual citizens are protected. There is the right. Data principals have the right to register, a complaint. Of course, falsified complaints can be penalized up to 10,000 rupees. The goal of the data principal is to ensure that they have the right against the data fiduciary. The reason for this bill is to ensure that the data custodians, like enterprises, like all of us, protect the right of the individual, people of the country. The goal, this was written for the citizens of India. This is essentially the fundamental reason why the bill is there. It is to protect each of us. In the process, however, the law requires you to follow certain guidelines, especially data fiduciaries, since we are talking to them at this point, to make sure that processes are adhered to. Law is, something that one can't take lightly anymore. Before this law, things were more operating from the standpoint of common sense. But keep in mind that the internet is not a walled garden. The landscape is completely open. India realizes that you could be accessing some information in the UK or the Europe or the US. So the guideline here is they want to make sure that the countries where you're accessing information adheres and is compliant to the laws of India. Where they determine that that particular nation is not compliant, they could be blacklisted.
So now tell me one thing. So how is the regulatory independence addressed?
The regulatory independence is addressed by the fact that the board members are typically only in their job for a couple of years. And after that particular point, they have to be reinstated through a standard process. And it's pretty much a rolling 2-year process.
So now let's talk about how Pinnacle can help clients in keeping up with new regulations.
So we do this for a living. We of course understand the Indian protection laws, data protection laws. In addition, of course, we support PCI compliance, we support SOC 2, ISO, CCPA, GDPR, which are all similar regulations. And our basic purpose of existence is to support customers to comply and ensure that they have the right security hardening for all of the data protection acts that have come up in all parts of the world, including India.
Okay. So now let's talk about applicability of this bill. So where will the bill apply concerning the processing of digital personal data? Next slide, Kimberly.
The bill applies to processing of digital data within India, whether it's collected online or offline, and digitized. It applies to processing outside of India, if it is for offering goods or services to India.
Okay. So now let's talk about responsibilities of data fiduciaries. So what are the primary obligations of data fiduciaries under this bill?
maintain data accuracy, ensure its security, and delete it once the purpose has been achieved. Again, we're going to double down on security. The data fiduciary has the obligation to making sure that the data that it holds as custodian is protected, which means that you have to have the right security processes, the right tools, and the services. Example, 24/7 monitoring, vulnerability management, all of these things are absolutely critical.
So this is a very key question, right? Which talks about the history. So how was personal data previously regulated in India before this bill?
India's regulation on personal data was under IT Act 2000. A committee of experts sat together and formed a committee in 2017 that was based on the study and findings. Then the Personal Protection Act came in 2019, was introduced. However, it was withdrawn and a new draft was introduced back in 2022, which became law in 2023.
And can you also throw some light on the key differences in the various drafts of data protection law?
The 2023 bill encompasses both personal and non-personal data and anonymized data, unlike the 18 bill. The 18 bill essentially, included notifying the authority for any kind of breaches. However, the 2023 bill, here is where I have to underline, highlighted in bold, that data fiduciaries, like all of us, have to report a breach within 72 hours. This bill permits the central government, of course, to have certain exemptions, but all companies, enterprises have to report any data breach, any harm to consumer data within 72 hours, which means that there is a financial impact to a company that reports it, because obviously when it goes in the news, such a company will be blacklisted potentially by their customers because they're going to be afraid of working with them. So key point here is for all of us to ensure that we are, of course, following the guidelines, hardening our security across the board so that we don't end up in this situation.
Okay, let's talk about consent and processing. So for what conditions can personal data be processed?
Personal data can be processed for lawful purpose under the individual's consent. However, consent might not be required for specific legitimate uses. Example, for permits for services that the government provides.
Okay, so that leads to the next question, which refers to the rights of individuals, right? So what rights does this bill grant to individuals concerning their personal data?
Individuals have the right to obtain information about their data, seek correction, erasure, as well as any redressal for grievances.
Now let's talk about data fiduciaries again. So what are the primary obligations of data fiduciaries under this bill?
Maintain data accuracy, ensure its security, and delete it once the purpose has been achieved.
All right. So now let's talk about cross-border data transfer, right? So how does this bill approach the portability or transfer of personal data outside of India?
The bill permits transfer of personal data outside the country because the government realizes that we don't run a walled garden. The internet is a free-flowing economy across the world, minus, say, China, that runs an intranet for all practical purposes. Now here, India is part of sovereign nations, democracy, like Australia, the US, the UK, and the works. So here, we're talking about the ability to freely transfer information. However, that protection may change based on the standards of the recipient countries. If the recipient country is, say, North Korea or China, the game may be slightly different.
Okay, so now can the government agencies be exempted from certain provisions of the bill?
Yes, absolutely. The central government can be exempt from the bill's provisions in the interest of factors like state security and public order.
Right. So next question would be, what will be the role of the Data Protection Board of India?
The central government will establish, of course, has established the state, the Data Protection Board to adjudicate non-compliance in the bill provisions. So in other words, they are the regulatory enforcer, just like, for example, you have SEBI that enforces the security compliance for public companies. And this is going to get bigger and bigger. This is just the beginning. The regulatory engagement that you're talking about from the Data Protection Board is just a start. I would view this as a teaser, and for more and more security-based protections for consumers and enterprises to only get bigger and bigger. Keep in mind that the current regulations are there. They're pretty steep. However, they're meant to blend into what we already have. But this is going to get steeper, and it is extremely important for enterprises like all of us to be compliant with this as quickly as possible. Because as it gets steeper, it gets harder to reach it. And of course, there are penalties associated with this.
So what would be the maximum penalty for failing to take such security measures against data breaches?
250 crores is the maximum so far, and which means that it can be a number anywhere from 0 to 250 crores. In essence, a company could be penalized 3-4 crores, 10 crores, 20 crores, depending upon the scale of the damage, which essentially means that the cost of non-compliance is large. It is probably cheaper to make sure that we have the policies in place. Case in point, if a company follows all the processes, which means that it is third-party audited by companies like us, you will probably be able to evade the penalty or violation because you've done everything humanly possible to protect yourself. However, if you have not been able to document, if you've not been able to follow the processes, and there is a violation, the penalty will be steep. Like I said, there is a get out of jail card when processes are adhered, when laws are adhered, and when you have security hardening and third-party audits performed on a regular basis. The odds of that becoming out of control is very, very less. And of course, there is public image, customer perception, and all of those things that have to be taken into consideration. Overall, a pretty serious matter for companies to follow. The reason is you have to report a problem within 72 hours, which means that you cannot hide a breach under the carpet. And that alone is enough reason for us to act and have the urgency to act now. Very many companies are still, we work with a lot of companies, many are still scrambling about this matter. Some of them really take it seriously and are moving ahead, but some are still, acting, in a way as if the regulations don't matter. Let me just make this clear. It's only a small hole that sinks a ship. So we have to make sure that there are no holes in this particular case. When we talk about a hole here, we're talking about a security hole. If you have a security hole, even one, that could sink your enterprise. So that is how serious this is.
So can you please tell us why might exemptions for data processing by the state be very concerning?
The reason is data collection and processing could, conflict with our fundamental right to privacy. But keep in mind that the state has the obligation to look at the collective interest of the entire population of, say, 8 billion in India. So while protecting the interest of one, if it comes at the cost of thousands of people, then the choice would have to be made to support the interest of the thousands or the lakhs or the crores of people that are involved. So that is essentially the state's fundamental dilemma. And that dilemma exists for every nation in the world. We are no exception. And the goal is to make sure that we, of course, do not put ourselves in a situation where there is a trade-off decision made between our individual right and the collective right of many citizens.
So can data fiduciaries be exempted from notice for consent?
The central government can notice certain fiduciaries, including startups, from certain obligations. This can include notice of consent. However, the requirement for free and informed consent will still apply.
All right. So let's talk about risk regulation. So does the bill address potential harms from personal data processing?
The bill doesn't specifically regulate risks of harms arising from data processing. Such harms could be financial loss, identity theft, reputational damage, discriminatory treatment, and unwarranted surveillance. So in essence, the risks of harm, for example, if a fiduciary has or a principal goes through, there is absolutely no way to regulate that risk, at least in this bill. I'm pretty sure that it's going to happen in the next bill because this bill will continue to get improved as things go into action. They are going to find there are challenges in implementing certain things, and the processes of continuous improvement is part of all of these does.
Are the rights such as data portability and the right to be forgotten included in this bill?
No, the bill does not grant the right of data portability or the right to be forgotten to data principals in this particular bill.
Okay. So now let's talk about how to handle cross-border data transfer, right? So can you please throw some light on that?
Cross-border data transfer is not restricted, to except where countries do not follow the law. For that could include, for example, potentially countries like Iraq, countries like North Korea, any country that probably is not, in the best of terms with India could be blacklisted. And of course, they're going to follow and check on how compliant they are and make those determinations, because cross-border data transfer is inevitable, because we are going to access the server in some part of the world. So it is inevitable back and forth.
Okay. So tell us one thing. So what concerns arise from the board members' appointment terms?
As it stands, the 2 years looks very, very reasonable. The independence provisions and the possibility of reappointment, all that look very reasonable. However, the proof of the pudding is how it's implemented and what happens in these 2 years.
Now let's throw some light on protection for children's data. So what is the bill's stance on data processing which is related to children?
Data fiduciaries must ensure that processing doesn't harm a child's well-being. Additionally, activities like tracking or targeted advertising towards children are strictly prohibited. So if companies are leveraging children's data for specific targeting, that is, children are considered anybody who's under the age of 18 is considered a child. So if there's any specific targeting through social media or other things, those things would be penalized.
And how does this bill address verification of age and parental consent for processing data?
The bill mandates data fiduciaries to obtain verifiable consent from the child's legal guardian prior to processing. This implies that every data fiduciary must ascertain the age of anyone using its services to determine if they are minors or they require a guardian consent.
Okay, and why is personal data so important for businesses and government entities?
Personal data plays a very pivotal role in delivering services. Understanding customer preferences, targeted advertising, recommendation generation, all of this are part of it. That is why this bill is there in the first place, because the very companies that actually monetize personal data include social media, include the e-commerce websites. So all of this collectively, trap us in actually sharing a lot of information, is because it's that information which is gold to them becomes a headache for each of us personally. And finding that unique balance is where these regulations come into being.
Okay, and so how might these exemptions impact the rights to privacy?
There's a potential risk that unchecked data processing by the state could infringe upon our privacy rights, leading to data collection and retention beyond what's needed, potentially violating our fundamental right to privacy. That risk exists in any nation. And of course, the government continues to maintain and try to ensure that the individual right is not compromised in the collective good. However, the collective good always takes precedence over the individual right.
And what risks are associated with unchecked processing of personal data?
Without proper controls, processing of personal data can lead to privacy infringements. Now, that has unwanted profiling of individuals, reputational damages, etc. As a data fiduciary, we have a huge obligation to making sure that we have the right data classifications, whether they're structured data, whether they're unstructured data, to make sure we data label them properly in a way that we can ensure that there is no data leakages in the process of data transfers or how it's stored, and how it's processed.
And does this bill have any exemptions?
Like I said previously, in specific scenarios, legal enforcement and investigations can take over, and at that point, the individual right does not become as important as the legal or the law.
Okay. So the next question is, what is the exact role of the Data Protection Board of India?
They are expected to oversee compliance, issue penalties, address grievances. That's their main role.
Okay, and I think we've already addressed, penalties.
But let me refresh everyone.
Okay.
If you are an individual that is falsifying information and complaining about data fiduciary, you could be fined up to 10,000 rupees. If you're a data fiduciary that does not do a good job in being a data custody, of being a custodian of data for the data principles, we could be fined up to 250 crores. And the only way to avoid that would be to follow the law, make sure you have done everything. It's very similar to driving a car in the road. Let's say you're driving relatively safely, you're ensuring that you have a seatbelt on, you have the right vehicle, and let's say, God forbid, an accident happens. You can, essentially go to the law and make sure that you get justice. However, if I'm speeding at 75 kilometers in a road that's only supposed to address 30 kilometers, and I run over somebody, there is no get out of jail card on that. So the very similar thing here, as long as we follow the law, do everything we can, and God forbid you still have a problem or a breach, there is a way out of it. That is documentation to prove that you've done everything possible. And that gives you the waiver for a penalty.
And are there any exemptions that the state has been granted under the bill when it comes to personal data processing?
The state has a lot of latitude with respect to how they do it. They're also expected to follow the same regulations like all of us. However, the state, being the government, can do things that us as individual private enterprises cannot.
Okay. So now it leads to a very interesting question, right? What provisions did the Sri Krishna Committee recommend?
The Sri Krishna Committee advised that obligations like data storage limitation and purpose specification might be addressed under a separate law. They felt only obligations of fair and reasonable processing and security safeguards should apply in the case of national security. So like I said, I expect this to further tighten and get more tougher in the next iterations of this law.
What did the Supreme Court state regarding the rights to privacy and state actions?
The Supreme Court has made it clear that any infringement of privacy should be proportionate to the need for such interference. And furthermore, it's mandated that safeguards for interception of communication on the grounds of national security should be handled with care.
And does the bill include provisions for the right to data portability and the right to be forgotten?
There are no provisions for that. And I think the key thing here is we have to make sure that at all times the balancing act happens, like the right to free speech, like the right to receive information. Its applicability may vary based on the data sensitivity and the public relevance, the individual's public role. So for example, if you're a public figure, the rules may be different. And the right to be forgotten as well as the right for data portability may apply slightly different. As it stands, there are no provisions.
Okay. And what is the right to data portability, basically?
The need for data portability is essentially autonomy, transparency, and accountability, aiming to give all of us greater control over personal data. As it stands, data portability is not something that as an individual, I can go and block a data transfer from happening between one fiduciary and the other fiduciary. So, but each fiduciary is expected to maintain, and be compliant with the law. But as such, as individuals, there are no rights on that front. But fiduciaries have the responsibility. So the way the law is written is, the fiduciary is responsible for those aspects, even though the rights of the individuals can be in the gray side.
So should there be any concerns, that an enterprise or a person, should be worried about with regards to data portability?
As such, like we have said, there are strong provisions for personal privacy protection, which means that every company now has to adhere to the data protection laws, just like we, for example, have to adhere to other compliances, whether that is paying our taxes, individual taxes, whether it's the company's VAT tax. The same thing applies now to data. So think of this as another tax on the enterprise. Same processes, just like you do for other things, you have to do the same here. Just like you have to pay your tax, file your taxes on time, do the same here as well.
And that leads to the next question. So what is the right to be forgotten entail?
The right to be forgotten essentially means that if we leave a digital trail that is not in our favor, we have no way of actually deleting it. That digital trail may remain. That's even more the reason why we're expected to actually do the right thing, because the trail of any bad behavior may continue to linger in the public domain forever.
And that leads to the last question that I have, that I want to ask is, are there any challenges in implementing the right to be forgotten?
The challenges essentially are the dilemma that the state has with respect to the individual and the relative importance in the public arena. For example, it is important, they figured out that it is important for the individuals to know about public figures. Partly, this right to be forgotten is not in the law for the simple reason that they want to make sure that everybody's information is permanently held in the digital space, so that in the event you want to know better about them, you're in a position to know. Case in point, if you have a public figure who has committed crime, you don't want that to get erased, so that the public can decide whether they want to vote for the public figure. That's just an example.
So with that said, I have finished asking all the questions. Now we can go to the next slide, please.
The next section really is about how we can specifically help you. Now that we have laid out what the law essentially says in simple layman terms, the real question is, where do you need help and how can we be helpful? I'm going to turn it over to Kaushik.
Thank you, Rangan. And thank you, Ranjini, for the wonderful question and answer. It was easy to follow and very specific. So as a company, we understand the implications and the importance of this law. And this law has come into existence for multiple reasons, and I'm happy that it has finally come in India at this stage. And I'm almost certain that it will be amended and become more, we'll get more clarity later on. But at this stage, we are at a stage where we have to ensure we own the responsibility of protecting the data that we have as data fiduciaries. So as our organization, which is into data management, cybersecurity, and AI, we have always been helping other organizations to enable them to make sure their data is protected. One of the key aspects or key outcomes of any cyber attacks is data breach. And I'm sure people here would be familiar with several data breaches that happened in Uber and Facebook and whatnot. And that can happen for a variety of reasons. And one of the most important reasons is wherein if your data is not protected, if you are not taking care of the data, then you basically welcome hackers to come and steal your data. And in that context, India has taken a very important step, especially with the increase in cyber attacks, by enabling all of us and ensuring that we adhere to this law of data protection bill. As an organization, we have experience implementing various compliances, and one of the key areas that is applicable here is we enable you to ensure you become compliant with this bill or amongst many other things. Thereby, you are not only protected and compliant by the law, but also protected by various cyber attacks, and attack surface vector of yours will be reduced. That is one of the important ways of ensuring your business is both compliant to the law and also stays protected. Rangan, if you want to add anything more to it, or if Ranjini, if you want to ask any specific questions on this, please go ahead.
No, I think the key aspect here is how your data is essentially stored, it's processed, and how it moves. At all levels, it needs to be managed according to how the law is written. There are many things here. If you're, for example, a credit card company, how you hold personal information. If you're a medical organization, a hospital, how do you actually handle the patient's data? All of these are protected. In the past, I could probably go very easily, ask about my, for example, I have two adults who are my children. I cannot actually go and secure their data from a hospital, even if I want to. I probably should get the approval from them to get it, unless they're minors. So it is very important for, say, a hospital to know when and how to share information. That is not something that in India, we have had a system to work. In the United States, for example, that has been in existence for a long time through HIPAA. That's an example. So depending on the industry sector, there is a lot that goes beneath it. However, at a broad level, every company now is expected to secure their data. Securing their data means you close your doors, your windows, to make sure that you can't have a hacker come and take over your system. If such a thing happens, you have to report a breach within 72 hours. And pretty soon you go into a database where your name as an enterprise is going to get listed as somebody that's not being compliant, and which essentially means that your customers and others will know about it and will have reservations working with you. So the processes here have completely changed the order of the day. Now you have to work with a security company that understands this, just like in the past, you worked with a tax professional who needed to work and help you with your taxes. The same process is now there for security. That's, in a nutshell, the layman's version of it.
Yeah, thank you, Rangan. In fact, I will steal some of your words that you had told me earlier. So, if you are not locking your doors when you go to sleep, it is safe. But if you are not doing it, it was up to you at some point. But now, if you're not locking your doors, if you're going to sleep in the night, it's a crime. So that's the kind of example that Rangan was giving earlier to me, wherein this data protection bill is ensuring, the government is ensuring that we take our own safety seriously. And when I say our own safety, it's not just individuals, but also entire organizations. So in our experience, what we have noticed is sometimes even the business leaders at the very senior most C-suite, etc., would want to comply with the law, or at least go ahead with some certain certifications to ensure the data is protected and their business interests are protected. But they might find it very difficult to implement these processes within their organization because of cultural shifts and cultural changes. But they can also have the situation when they were tight-knit protected organization, but when they acquire another organization, then this can lead to challenges because of cultural changes, etc. So in that aspects, these kind of bills will help us as organization leaders to have a particular metric so that we can reduce the risk and enforce some of these compliances across the organization, and also enforce these amongst people who are having no other, who are not necessarily as sensitized to the importance of data protection.
So, for example, in our engagement with our clients, we, for example, look at the gaps. We look at where you are in your current processes and assess your gaps across a number of different dimensions. One easy and good way to do this would be to actually be compliant to certain standards like CIS 18, SOC 2, HIPAA, PCI, GDPR. So what happens is when you actually get compliant with one or more of them, you automatically get compliant with this law as well, because there are laws that have been in practice now for some time. Example, if you are in the credit card processing business, PCI would be a good one to do, among others. We, of course, implement all of these things. Even if you choose not to go through the compliance or the certification route, the risk assessment can point out the gaps and can enable you to be hardened from the standard industry protocols. And of course, we have figured out how to actually combine them in a way that is meaningful, actionable, and quick. The whole idea is not to add a bureaucracy to this that takes 2 years to implement. The goal is to implement it in 2-3 months if possible. Back to you, Kaushik.
Yeah, I also just saw a question here as to what are the repercussions of the data breach if it was not reported. I'm assuming the not reporting within a stipulated time or not taking care of this or adhering to this data protection bill will be proportional to the amount of penalty that the organization will have to pay. So if you are non-compliant, if you are not reporting, if you are not following these rules, again, these rules are meant for a reason, to protect ourselves, just like the way we wear helmet. It is meant for our safety. And if you are not doing it, then if you made for an accident and you had a head injury, then who are to be blamed? So if we are not ensuring we are compliant with all these data rules, then it'll obviously be proportional to the penalty, which can be up to 250 crores, I believe.
So the size of the organization, the size of the problem, of course, the reporting, I'll say the worst thing is not reporting it, hiding it, and doing those sorts of things. And those things were possible up to this point, no longer the case. So, like I said, it has to be reported within 72 hours. Yahoo, for example, had that issue many years ago in the US, failed to report it for several months, and of course got highly penalized. They probably lost about $1 billion in just a cybersecurity breach. It's not uncommon for companies in the US, for example, to lose about $20 billion on a breach. Some companies even go out of business. That hasn't been the case in India up to this particular point, but that's changing. There are many slides here, but I think we can skim through them, to show you all the protocols that have to be followed. For example, the data transfer protocols, moving on to the next one, would be the training and awareness. You have to have a security awareness and training program in your company because, it is not only important that you implement it, but you actually have processes to do so. Third-party assessments, any technology security infrastructure reviews, incident management processes, legal, continuous monitoring and feedback, stakeholder communication, all of that has to be practiced. I'm just going to fast forward so that there's time for any questions to the call to action as well. And we are, between Kaushik, myself, and Ranjani, will take any questions at this particular point so that you have a chance to ask any things that you want to clarify.
Rangan, I will read out the question. Does the bill address cross-border data transfers? And if so, what are the results and requirements for such transfers?
Yes, there are cross-border protocols. For example, there is actually what is called a data sovereignty evaluation, ensuring data transfer adheres to the territorial and jurisdictional laws of both source and recipient countries. Partner compliance review, evaluating the compliance posture of international partners and third-party vendors. All of that, are part of the cross-border data transfer protocols, which means that if you're dealing with another entity, it is important to know their security posture as well, because their security posture may actually impact yours. This is actually called third-party compliance. And that is an important one to understand. And of course, if you're dealing with a country that's not in good terms with India, that could be North Korea, it could be China and whatnot, there could be other factors to consider.
It is asking for a summary of this protection bill. Like the question is, what are the key provisions and implications of the Digital Personal Data Protection Bill 2023 in ensuring the safeguarding of personal data in the digital age?
Good question. Let me summarize it. It starts with data classification, mapping, and inventory. It starts with understanding and having robust consent management systems. It also includes strengthening of the data fiduciary processes, including data accuracy, robust security practices, retention policies. This is about individual rights. So what we want to do is to make sure that we are able to continuously stay updated to the directives, the regulatory audits. It is like a financial audit. It is like a tax audit. It's exactly the same, except it's on the security end of things. We want to make sure that there is a continuous learning and global alignment. We want to understand the data definition. How do you actually label data, personal data, etc. There is a process for educating employees. Following that is extremely important. The consent management mechanisms play a big role. International data transfers has to be clearly understood. Monitoring how the central government can potentially blacklist a country for a certain period of time. Just like how you do import and export of goods and services, you want to make sure you look at data as import and export of data and follow the same regulations around it. Understanding penalties, understanding that you have to secure your data. First of all, at the foundational level, it is important to understand how to secure your data, what processes to follow. So that's at the heart of this.
So would you like to have a closing remark if I don't see any more questions, please?
We are here to help at the end of the day. I think the law is relatively nascent, new. It takes a lot of expertise and an expert help to actually guide you through this. Our goal is to help you educate and help you, wherever your needs are. I think a simple assessment will tell where the gaps are. I think look at us as a GPS to this. A GPS essentially guides us today to a destination that we want to go to. And we're nothing but a GPS. And we know exactly what needs to be done. We support customers in India and globally, and have a lot of experience working in this space, and have the tools, processes, the technology, the resources to assist you to not only get it done right, but get it done fast. Our services can be boiled down to three: the comprehensive security services that includes complying with the law. We want to make sure that we're competitively priced so that you're not paying a bomb. And number three, we want to make sure that the marginal cost of this compliance doesn't break your bank. So with that said, we look forward to hearing from you.
Yes, I just want to add one more thing. We want to ensure you are protected. Don't wait for you to be breached. I mean, the people we work with, we want to help, we want to be useful to you, and we want to ensure we are all protected in this. So don't wait for you to be breached to wake up and then realize, oh, I should have worn a helmet or followed the data protection bill. Please reach out to us. We are always here to help, even a casual call is fine.
I think there's one question that asks about when are we supposed to be expected to comply with the new law? I mean, as of now, it's ASAP, which means that there isn't a whole lot of time available because the law is already in motion. And, I'd say the amount of time that really is available is the amount of time it takes to implement the processes. That's really what it is. We thank everyone that's attended the webinar today. We look forward to meeting you individually and helping you in your journey to comply with this law. All the very best, and we look forward to seeing you soon.